Hello, everyone, and thank you for joining us today for our educational webinar. My name is Jonathan Marashlian. I'm the managing partner of Marashlian and Donahue, the CommLaw Group. I'm going to moderate today's discussion about complying with the CVAA. CVAA stands for the Communications and Video Accessibility Act, which is a law passed in 2010 that extended a variety of disability access rights, duties, and obligations to include manufacturers and providers of advanced communications and video equipment and services. I'm joined today by my colleague, Rob Jackson. Rob heads up our firm's CVAA compliance team. I'm also very excited to have Sharon Rosenblatt with us. Sharon is an IT specialist at Accessibility Partners, LLC, one of the nation's leading CVAA consulting firms. One of the things we try to do at our law firm is to find and partner with best-of-breed businesses that specialize in unique and oftentimes complex regulatory areas, such as disability access to telecommunications and advanced services. By finding, vetting, working together, and partnering with best-of-breed providers like Accessibility Partners, we're able to more efficiently and effectively develop solutions to fulfill each client's unique needs. Later on in our presentation, Rob's going to describe some of the many benefits our clients can achieve by working together with counsel and third-party specialists like Accessibility Partners through carefully crafted arrangements that seek to protect sensitive and confidential information. So without further ado, I'm going to turn over the microphone to Rob Jackson. He'll be guiding you through the first set of slides before handing off to Sharon. Thank you, everybody. Enjoy the presentation.
Thank you, Jonathan, for that introduction and for coordinating today's webinar on the CVAA. Anytime Congress comes out with a new law or the FCC issues new regulations that attempt to regulate the rapidly evolving area of advanced communications, there are bound to be issues, questions, and uncertainties, and of course a great deal of non-compliance as a consequence of these uncertainties. We're excited about the size and diversity of our audience today, and we view this as a testament to the strong desire of the communications industry to not only follow the FCC's rules for CVAA compliance, but also to develop services and products that are more accessible to customers with disabilities. The CVAA presents service providers and manufacturers with opportunities to expand their customer base and to make more sales. That beats a tedious compliance exercise any day. We'll walk through the CVAA and its requirements with discussion of both technical compliance and the very important record-keeping obligations. We'll take your questions as well. Afterwards, you can email them to us. Please make sure you remember this. We'll get to as many as we can and as soon as we can. So let's get started. I'll discuss the CVAA, the policy goals behind the law, and the FCC's implementation of the Act. Sharon will talk about what constitutes disability, assistive technology, and business drivers for compliance. I'll jump back in for a deeper discussion of the FCC's implementation, compliance, and its challenges, as well as risk and exposure to both FCC enforcement and the ever-present civil lawsuit, which is so often a class action. I will inform you about ways Marashlian and Donahue, along with our network of technical experts, can assist your company with cost-effective compliance and bolster your defenses against an agency enforcement or lawsuits. And then Sharon will talk about her company's services. For many years, Congress and the FCC have required carriers and manufacturers to provide access to telecom services to people with disabilities. For example, long-standing rules require hearing aid-compatible telephones. 30 years ago, the FCC required discounted long-distance rates for TDD users. Carriers and their customers pay fees to operate the telecommunications relay services, or TRS, for hearing-impaired and non-hearing-impaired customers to communicate with each other. But meanwhile, technology in the market continued to develop, and they got way ahead of government rules. As a result, Congress passed the 21st Century Telecommunications and Video Accessibility Act, CVAA, to update our nation's telecommunications protections for people with disabilities. Change technology, broadband availability, and public safety needs drove Congress to amend the Communications Act of 1934. All right, the CVAA regulates both services and devices, chiefly those that are used over broadband internet connections. The Act has two separate titles. Title I addresses communications access, and it covers newer cell phones, specialized VoIP phones, personal computers, laptops, and tablets. Video conferencing equipment, these are known as covered products, as well as text messaging, email, instant messaging, and interactive video communications. These are known as covered services or advanced services. As technology and market forces continue their constant march of change, we expect the CVAA may be well interpreted to cover new but similar products and services, for example, the Internet of Things. But that's a topic for another day. Title II regulates video programming. It covers TVs and other devices capable of displaying video programming. Again, newer cell phones, personal computers, laptops, and tablets, and programming servers and set-top boxes. These are covered devices for Title II. And all video programming that broadcast or cablecast on TV that is also shown over the Internet. That's covered services. And of course, both titles expand access to public safety services, enhance the new generation 911 and emergency alert system. So bottom line, if your company provides advanced services or TV programming to end user customers, it likely has CVAA obligations. Similarly, if your business manufactures devices that use broadband connections to deliver advanced services to consumers or devices that deliver TV programming over the Internet, it most likely has CVAA obligations. We'll talk about what that means in a few moments. What about ordinary carriers who simply transmit the ones and zeros that constitute advanced or video services? Section 2A of the CVAA exempts entities that only transmit covered services or provide an information location tool. The CVAA exempts ISPs and operators of broadband platforms that provide web-based access to email or instant messaging. The law excludes storage, transmission, or routing functions. For example, a company that merely stores covered messaging services is not itself under the CVAA's obligations. Likewise, a platform that only offers a directory, index, reference, pointer, menu guide, user interface, or hypertext link that accesses covered services is not covered by the CVAA. This is similar to the concept of the rule of law that excludes ISPs from liability for what their subscribers say or publish over the Internet, and is similar to the rules that have governed common carriers for many years for their subscribers' speech. The FCC's test or rule of thumb is a mere, quote, passive conduit, unquote, does not carry with it CVAA obligations. On the other hand, if a carrier's IP transport service interferes with, blocks, or otherwise negatively affects advanced services, the IP transport is not a passive conduit. It has compliance obligations. If that exists, your company needs to be talking to us. Now let's go to Sharon, who will tell us about disability and accessibility.
Great. Well, thanks so much. If we just jump to the next slide. To start off with, the word disability can mean different things to different people. Trying to come up with an overarching term is difficult, but the Americans with Disabilities Act of 1990, or the ADA, has a working definition. Under the ADA, an individual with a disability is a person who has a physical or mental impairment that can substantially limit one or more of their major life functions. There are a wide variety of disabilities, and within these, there are naturally a lot of overlap. Some of the disabilities included are blindness and low vision, deafness and hearing loss, limited movement, speech disabilities, cognitive limitations, or combinations of the above. People with disabilities are the only minority group that anyone can enter at any time in their life and at any fashion. If we move to the next slide, about assistive technology, broadly, assistive technology, or AT, is technology used by people with disabilities to perform functions that might otherwise be difficult or impossible. Assistive technology is a small but established field. It can consist of any type of technical device that helps a person with a disability. These types of items can include walkers, wheelchairs, hearing aids, and TTY phones. Yet, there is much more assistive technology that the average person does not immediately think about. Assistive technology includes all types of hardware, software, and peripherals for computing devices. Tools such as screen readers can read text that is shown on a screen to users with visual disabilities. Other assistive technologies that those with visual disabilities can use are screen magnifiers and color contrast devices. Sometimes, people with disabilities cannot use a standard keyboard or mouse. Assistive technology, known as augmented input devices, for use with those with mobility and dexterity disabilities can be helpful. These can include on-screen keyboard or sometimes braille keyboards. Joysticks can help users put in information if they also have mobility impairments. There are other ways to input information through mouth sticks and speech recognition software. You might be aware that your phones have speech recognition already built in with programs like Siri for the iPhone. Video phones are also a type of assistive technology. They help with the increasing demand of face-to-face communication. Video phones allow users to communicate in a variety of formats, whether through text or audio, to anyone who possesses the same software. Plus, for a person with mobility disabilities, it removes the need for movement to a meeting. People can meet anywhere and anytime with a video phone. We jump to the next slide about business drivers. Let's look at the numbers for a second. 1 out of every 3 households in America includes a person with a disability, which shows just how common living with a disability really is. Over 60 million Americans have at least one disability. This translates to about 1 out of every 5 Americans. As the baby boomer generation ages, disabilities will only become more common. Most disabilities are acquired as people age and some of their faculties decrease. It's unavoidable, but leads to an increased need for accessibility and technology. There are currently about 76 million baby boomers living in America at present time. Furthermore, because of the growing amount of people with disabilities, this is a huge market. People with disabilities have an estimated discretionary income of about $220 billion. Thus, this makes the accessibility market a tremendous commodity. The marketplace is changing fast. From your employers to the customers you serve, disability is truly commonplace. It is wise to tap this powerful group now. Having recognition for being a company that provides accessible products and services to people with disabilities can create long-standing loyalty. Once the loyalty is established, people will continuously use that service, and everyone benefits from having a long-time, satisfied client. Of course, the CVAA and other accessibility regulations are the law, and you want to be compliant. Now, let's go back to Rob to learn more about the FCC's implementation of the CVAA.
Thank you, Sharon. The FCC has adopted rules to implement the CVAA. Most of those regulations became effective in 2012. Examples are video description. There must be audio narrated descriptions of a television program's key visual elements. There's record-keeping compliance. Entities subject to duties under Sections 255, 716, or 718 of the Communications Act and the FCC's rules implementing those sections have obligations. Those covered entities must submit record-keeping compliance, certifications, and contact information to the FCC annually by April 1st. And as a matter of background, note that Section 255 of the Communications Act covers access to telecommunications services and equipment for service providers and manufacturers. Section 716 covers access to advanced communication services and equipment, and Section 718 covers Internet browsers built into telephones used with public mobile services. The CVAA and FCC rules also govern the National Deaf-Blind Equipment Distribution Program, NDBEDP. This program enables low-income individuals who are deaf or blind to access 21st century communication services through targeted subsidies. The new rules also regulate the captioning of Internet video programming. FCC rules require captioning of TV programs when they're reshown on the Internet, and the display of captioning on equipment used to view video programming. This extends closed captioning requirements to other devices used to view programming, such as smartphones, tablets, personal computers, and television set-top boxes. Some other new rules and decisions took effect in October 2013. These include regulations for Section 718, which again is access to ACS and equipment, that were made consistent with the existing Section 716, Internet browsers and mobile phone regulations. That helps. The FCC did, however, decline to adopt requirements for or safe harbors with respect to accessibility application programming interfaces, or APIs. And it retained Section 14.31's record-keeping requirements for manufacturers and service providers subject to Section 718. Also covered are providers of interconnected text messaging services, including wireless common carriers. They must transmit bounce-back messages to senders of 911 emergency text, or SMS, in locations where text to 911 is not available. The FCC adopted other rules that have taken effect or will take effect after March of 2013, including rules related to access to emergency services. Effective in January 2014, set-top boxes for video programming services and related devices, including other devices used to receive or play back digital video, ranging from televisions and computers to tablets and smartphones, must provide on-screen text menus and guides with audible, accessible, and a button, key, or icon for activating certain accessibility features such as closed captioning. Non-navigation devices must make their other built-in functions accessible. Finally, there are outreach requirements to inform the public about the availability of accessibility options and a procedure for making complaints to the FCC. The record-keeping rules require OMB, Office of Management and Budget, approval to take effect. Effective a year from now, May 2015, emergency information provided within video programming must be accessible to the visually impaired. Certain equipment must be capable of delivering video description and emergency information to those same individuals. And manufacturers of covered video devices must make available the secondary audio stream, which is currently used to provide video description and which will be used to provide oral emergency information. The FCC reaffirmed and refused to change the obligation for Internet browsers used to provide advanced services also constitute software subject to Section 716 of the Act, and they must be available by people with disabilities unless doing so is not achievable. Finally, the FCC is still considering other CVAA-related issues. There's a petition for reconsideration of the user interfaces order and the application of the IP closed captioning rules to video clips, that is, excerpts of full-length programming. Now let's look at some of the problems, or if you prefer, opportunities with CVAA compliance. As you probably know, the standards are not well established. The Act and the rules are intentionally vague and intended to be developed in a flexible manner to achieve broad access to advanced services and related devices for those of us who have disabilities, a group that increases as the average age of Americans increases. But we do know that several factors are likely to be considered in determining compliance. These are the needs of people with disabilities, limits and promises of technology, and cost for compliance. What's needed? What can be delivered at a reasonable cost? It's important to know that there's no obligation to retrofit products and services that existed before the FCC's rules took effect. But most, if not all, post-2012 products and services are not likely exempt from compliance obligations. So if you introduced a new tablet or an enhanced email service in October 2013, which is not CVAA compliant, you likely have a compliance issue that we should be discussing offline. Let's dig a little deeper. If a service, let's try instant messaging, cannot be used by anyone with visual impairment, your company will likely have a compliance problem. But if instant messaging can be accessed verbally on 2 tablets, 3 smartphones, and 5 laptops you manufacture, there would be less concern, even though other products manufactured by your company are not accessible to the visually impaired. Perfection is not the enemy of good with respect to CVAA compliance. I would not recommend, however, that for a big manufacturer building compliance into only its highest priced devices. There should be some level of compliance with low-end devices, unless this is simply unaffordable. The same logic applies to service providers that also sell or lease equipment. Service providers should work towards full accessibility for their offerings using a reasonable set of devices, if applicable. Dialogue with disability interest groups can be useful. Explain your situation and ask for feedback. A company that reaches out to the disability community is less likely to be viewed as unresponsive, even where accessibility gaps exist for some products or services. And we and our network of consultants can assist with this outreach. Reasonable good faith efforts will go much farther than a narrow legalistic reading of the rules. And document, document, document. You need to have good contemporary records of what your company has done to comply with the CVAA. Each product or service should have its own story in a CVAA compliance file. Here's what we looked at. Here's what we found. Here's who we talked to. Here's how our plan to ensure if future service offerings or products are compliant. Here's who we consulted, and here's what they recommended. And that's just for 2014. To be compliant with record-keeping obligations, a service provider should review its services annually. The same goes for manufacturers. Here's Rob's rule of thumb. Imagine the FCC opens an investigation of your company's CVAA compliance. The state attorney general sues your company for violating a state disability law, or a process server has just delivered a class action summons to your registered agent. What do you want to be in your file? What don't you want the other side to see? We can work with you and consultants to develop a CVAA file that protects your company. What if you don't or cannot comply? What are the risks? Well, the first risk of noncompliance is FCC enforcement. The Commission has statutory authority to impose cash forfeitures and impose greater CVAA obligations, such as the duty to caption additional programming beyond what you would otherwise be required to caption. CVAA violations can result in forfeitures of up to $100,000 per violation, or for each day of a continuing violation, up to a maximum of $1 million, and orders to bring products into compliance. Being the target of an FCC enforcement proceeding is not a pleasant experience. And think of the bad publicity. Your competitors would love to be able to point out that your products and services are not easily accessible by the many Americans who have a disability. Also note that the FCC has developed a new streamlined complaint process for consumers. It's easy for a disgruntled consumer to file a complaint because she or he cannot send email messages orally. And once a complaint is filed, it won't be ignored if it has any merit. A much better approach is to work on and achieve reasonable compliance. If that's not doable, it may be possible to get a waiver from the FCC. For example, this year the Commission issued an order grandfathering for 1 year non-compliant e-readers that were designed for text-based digital networks, even though they could provide access to ACS. In the case of the FCC, it's better to ask permission rather than forgiveness. What about complaints against wholesale providers? The FCC would expect a wholesale provider to provide evidence that its service is a passive conduit. Without good evidence, a complaint could be challenging for defendants. Hence, document, document, document. I don't think the FCC would investigate a wholesale provider without an actual complaint being filed, though. And now let's look at lawsuits, especially class action lawsuits. The CVAA does not allow for private enforcement. Only the FCC has statutory right to enforce the law. But courts have held that private parties can bring suits under the Americans with Disabilities Act, ADA, or state disabilities laws, which permit private enforcement. And they can raise CVAA standard issues in these lawsuits. In other words, judges can impose CVAA requirements in ADA or state law actions. The leading case is National Association of the Deaf versus Netflix, a federal court case in Massachusetts. This was a suit by a deaf person in a related interest group under the ADA to force Netflix to provide closed captioning on all its Watch Instantly programming. The case settled with Netflix agreeing to close caption all Watch Instantly programming by September 2014. As per the consent decree, Netflix also paid attorney's fees and $40,000 to the NAD to monitor compliance. This is probably just the tip of the iceberg. There will be more class action lawsuits involving CVAA access issues. Why do I think this way? Do you watch cable TV? Have you seen the many commercials seeking class action plaintiffs for this, that, or another product? Have you seen the class action websites? Class actions are big business in the United States, and communications-related lawsuits are significant. What do we think about CVAA litigation risks? Who has higher risks? First, let's talk about providers of covered services and equipment. The obvious conclusion is that larger companies have more visibility and have more risk. Verizon, for example, has more visibility and exposure than a small interconnected VoIP provider. But that small provider can still be the target of a small law firm or sole practitioner. All covered service providers and manufacturers need to make good faith, reasonable compliance efforts in order to reduce lists. And again, document, document, document. Sticking one's head in the ground is not a good idea. The defendant needs a paper trail showing compliance efforts. Further, covered businesses need to establish collaborative relationships with disability groups, either directly or through their trade associations. And as I've mentioned before, we and our consultants can help with that outreach effort. The risk of litigation for wholesale providers should be quite small. But a wholesale provider needs evidence that it looked at its services and determined that they are simply passive conduits. The existence of incorrect statements in the documentation could increase the risk of litigation. We examined our IP transport. It cannot affect CVAA covered services under any conditions. Yet somehow, somewhere, an engineer will find a way that transport services can, under some unique circumstances, interfere with the delivery of adaptive services. Recall the massive SS7 failures of the 1990s that were caused by minor glitches. How does a wholesale provider square its earlier statement that we have no impact with that of the plaintiff's expert engineering witness who says, yes, you can under these circumstances? The time for review and documentation is now. While the risk of direct litigation on CVAA claims, ADA or state law-based, is quite remote, wholesale providers need to be aware of being pulled into other companies' lawsuits. A retail service provider faced with a massive class action may well decide to implead its wholesale carrier and claim transport services contributed to the retailer's inability to comply with CVAA accessibility. Litigation allows defendants to try to pass on blame and seek monetary contributions. Rule 14 of the Federal Rules of Civil Procedures allow defendants to implead those into their case, those persons or companies who might be liable to the defendant. Most states have similar rules. Even an innocent wholesale provider might find itself faced with increased legal fees and nuisance settlements. And disability rights groups are more aggressive today. Their members are unwilling to accept second-class citizenship or exclusion from advanced services. It's of critical importance to have some form of direct or indirect relationship with disability organizations. Our compliance services. Marashlian and Donahue has established a broad network of connections with companies, consultants, engineering firms, nonprofits, disability interest groups, colleges and universities, and the FCC's Disability Rights Office, which it can leverage to provide valuable information and compliance services, including the evaluation of products and services for CVAA compliance, negotiation and consensus building for the establishment of compliance standards, cross-sharing of information and identification of cost-effective solutions, i.e. the avoidance of overly expensive fixes. Compliance and certification can be obtained through M&D with the potential availability of attorney-client and work product privileges to protect confidential information. This is not available through the direct hiring of third-party entities. Given the unsettled state of CVAA compliance, M&D clients can also obtain early mover advantage, helping to set cost-effective compliance requirements as opposed to being governed by other parties' consensus. Early movers can have a great advantage. More information about our compliance network members can be obtained after the execution of a non-disclosure agreement, an NDA, with individual or group members. Sharon, can you tell our participants more about Accessibility Partners?
Great. I'm happy to jump back in. So if we jump to the next slide, Accessibility Partners is headquartered in the Washington, D.C. area. We are an accessibility consulting firm focused on the accessibility of information and communication technology. We have subject matter experts in accessibility, including Section 508, which is part of the Rehabilitation Act and covers the accessibility by the federal government, as well as the World Wide Web Consortium, or W3C's Web Content Accessibility Guidelines, or WCAG, and of course the FCC's 21st Century Communications and Video Accessibility Act, or CVAA. Here at Accessibility Partners, we have staff who are expert users of assistive technology products such as screen readers. Having a diverse staff of people with disabilities gives us a unique insight into the individual experiences of a wide range of technological users. Our clients are in the public and private sectors, from technology companies to telecommunications, as well as education. If we move to the next slide, our core service is accessibility testing and the auditing of products and services. Some of the types of things that we have tested are software and web applications, like web portals and security tools. Others are hardware, such as laptops, cell phones, and tablets. What is most challenging is that some of today's devices, such as those cell phones, combine aspects of hardware and software into one package, which brings several accessibility considerations into play at once. Accessibility Partners monitors legislation, guidelines, and standards as they pertain to accessibility both nationally and internationally. This helps us to be current on the accessibility landscape and to guide our clients for the immediate and for the future. We understand that sometimes products and services have a long-term horizon for implementation or for their expected lifespan, and our clients need to be prepared and keep surprises to a minimum when possible. If we move to the next slide, when Accessibility Partners takes on a project, we look to understand what our clients actually need. The testing of products, explaining what we found, and helping to plan for accessibility enhancements where they're needed helps position our clients as leaders in providing accessible products and services. We also recognize the ROI and understand the value of accessibility and hope to translate that to our clients. In addition, we've conducted many white papers, speaking engagements, as well as case studies remarking about accessibility. Move to the next slide. An accessibility audit can lead to compliance with accessibility law such as the CVAA. This audit finds how a product or a service stacks up with accessibility guidelines. It focuses not only on what is wrong and inaccessible, but more importantly, what is accessible within the product. These findings can serve as a guide for future enhancements, as well as to promote what the product already does well. In addition, as we heard about before, the documentation from an accessibility audit can support the record-keeping requirements of the CVAA. In the next slide, in an accessibility audit, the focus is on the end user and how he or she interacts with the product. Users may have various disabilities such as blindness, low vision, deaf and hard of hearing, and dexterity disabilities. Part of testing a product is to consider what common assistive technology a typical user with a disability would use to gain access. For instance, a blind user often uses a screen reader to read text shown on a computer or a cell phone screen. Then, how well does the product work with the assistive technology currently? What can be changed to allow it to work better? These questions can be answered in an accessibility audit. So if we move to the next slide, briefly, the testing methodology is, first, reviewing the requirements, specifications, and product documentation. We do this to understand how the product is intended to work. Once we gauge that understanding and comfort, we develop a test plan based on the requirements of the law, such as the CVAA and Section 508. We then test the product using that combination of automated test tools, assistive technology, and manual inspection of the product to make sure that we unearth all of the areas of user interaction and how a user with disabilities would interface. When possible, we include people with disabilities to ensure real-world feedback. Accessibility Partners makes it a strong point to employ skilled testers with disabilities. A comprehensive report, including a gap analysis and optional remediation suggestions, is then prepared for our clients. If we jump to the next slide, following that audit, the compliance documentation is created. For example, for a CVAA-based audit, the documentation will list how the product complies to the CVAA. This might be similar to those who are aware of the Voluntary Product Accessibility Template, or the VPAT, for Section 508. The CVAA needs several documents, including statements on accessibility of the product, the information about the compatibility of products and services with peripheral devices, specialized customer premise equipment commonly used by individuals with disability to achieve access, and efforts, of course, to consult with individuals with disability throughout the product life cycle. If we move to the next slide, the final documentation package ensures compliance with the FCC's record-keeping rules as part of the CVAA. An affidavit or declaration is filed annually on or before April 1st, stating that the CVAA accessibility documentation does exist. The annual filing also includes contact information for the consumers and a U.S. agent for service contact information. So that's a bit about the CVAA and our testing and audit methodology. You can feel free to reach out to us at Accessibility Partners. Our web address, www.accessibilitypartners.com, is listed on the screen, as well as our email address, info@accessibilitypartners.com. And as always, feel free to follow us on Twitter and Facebook. We're always updating just about what's going on with accessibility, new laws and regulations, and other sorts of accessibility-related news.
Well, thank you very much, Sharon. That was extremely informative.
Welcome.
And if, as we said earlier, please send any questions you have to either to us at the law firm or to Sharon at Accessibility Partners, and we will share them with each other and get back to you. And with that, I think on behalf of Jonathan, Sharon, and myself, I'd like to thank you very much for joining us today. And we wish you a pleasant rest of the day.